And we wanted to kick off the supervision webinar series for 2017. There will be probably more webinars this year and more news alerts than ever before, directly attributable to our new president. The White House has already caused quite a bit of fervor. And in this new year, there is going to be a completely new outlook both on labor and employment laws, regulations, and how these laws are being enforced by the EEOC and the Department of Labor. And obviously what everyone is anticipating is a much more pro-employer, pro-management stance. With the changing administration, I would dare say that there have been by far the most phone calls and emails that Spencer and I and the rest of the employment group have gotten over the Affordable Care Act. Most likely, if you're attending this webinar, you've spent a lot of the last few years trying to understand Obamacare and the Affordable Care Act and get your business compliant with it. And then you're greeted with news and headlines saying that it's no longer in effect and it's being repealed. We will be following up when there is an actual change in the law under the Affordable Care Act with some legal guidance. What you all need to know right now is the administration has clearly signaled that Affordable Care Act will be going away. It will be, if it's even left in name only, it'll be a shell of its former self. But be careful. It is still the law today, and it is absolutely vital that you not change any of your compliance that you've already laid out. There will be changes, and please be on the lookout for news alerts on that. Again, let's talk about the wage and hour law changes, the changes to the overtime rules that we've been really struggling with throughout 2016 and when the proposed regulations were announced even before that. Very dramatic changes to the overtime rules and the salary test. And a lot of you all made very significant changes in your business practices, in your pay practices, changing people from exempt to non-exempt or giving significant raises to get compliant. And as everyone on this call should know, there was a court that blocked the enforcement of those final rules. And there's an injunction in place. So the overtime rules did not, in fact, change, even if you changed your own internal proceedings. What we're expecting and forecasting with this new administration is the Department of Labor, who is litigating to overturn that injunction and put those new overtime laws back into place. We're not so sure that the Trump administration is going to really litigate those points. So keep an eye out for those. But one important factor to keep an eye out is the minimum wage laws. President Trump, while he was running for office, was an advocate to a fairly dramatic change in the minimum wage laws, increasing it maybe upwards as much as $10. It may come gradual, it may come all at once, or it may not come at all. So we wanted to forecast some of these initial issues that we're expecting under the changing administration, and we'll be updating you with news alerts and subsequent webinars as those roll out. But we wanted to begin with talking about the pay equity laws. And if everyone watched the Super Bowl last Sunday and the greatest quarterback of our time, Tom Brady, instituting a great comeback, there was a commercial by AUDIT. And it was a really interesting commercial entitled, How Do I Tell My Daughter? And it was, how do I tell my daughter that her grandfather is worth more than her grandmother? How do I tell her that I'm worth more than her mother? And how am I going to tell her that that she won't be valued as much as men? And the punchline to that was, I hope I don't have to. And that's really what these pay equity laws are about. And clearly, it's a part of our culture today. And it's something that is of profound importance. Of course, if you see it on the Super Bowl, you have very vocal commentary coming out from the Vatican and Pope Francis, calling for an abolition of any forms of pay inequity. And from the other corner of the universe, you have Bono, the lead singer of U2, making it a part of his big social agenda. So it's clearly out there for everyone to be focused on. And we were going to talk in a few minutes about what we were treated to over the last 8 years in the Obama administration. But before we do that, let's just reset a little bit and make sure everyone understands when we're talking about pay equity and fair pay, we're all talking about the Equal Pay Act that was passed over 50 years ago, back in 1964, as a part of the civil rights movement. And what this law did, it sounds very simple. Equal pay for equal work. And it shouldn't be a controversial measure, but in fact, women were paid grossly disproportionate to men for equal jobs. And although the change over the last 50 years has been slow, it has in fact been effective. The government did not start keeping statistics on pay disparities until the end of the 1970s, but from the time they did until the most recent census, we have seen the gap change by 20% just in that time period. But still today, what this chart tells you is that for the same work, for equal work, women are paid 81 cents to every dollar that men are paid.
So as Jeff just showed you, the wage gap still exists despite its upward trend. With that in mind, how does the Equal Pay Act address the wage gap, and what does it require you to do? Well, as Jeff already said, it requires equal pay for equal work. But no, the equal work does not mean identical jobs. We can't just look at job titles to determine whether employees are performing equal work. Sure, it may be a good indicator, but it's also possible that, for example, your administrative assistant, your secretary, and a paralegal all perform the same tasks. So therefore, when we're looking at the Equal Pay Act framework, we need to look at, whether your employees in question perform jobs that require the same skill. Do they require the same effort? Do they have the same responsibilities? Are they performed under similar working conditions? And are they performed in the same geographic location?
So what you're looking at here is when it says equal pay for equal work does not mean identical job title. And what Spencer is referring to here, and you see that on your computer screen, there are factors that you need to look at to determine when you're looking. It doesn't matter if the jobs appear to be completely different. You need to look at these factors, even if the functionality of the job appears different. If it is a same level of effort and skill and responsibility, positions that you wouldn't consider to be the same might be equal for purposes of the Equal Pay Act. But it doesn't mean that just because two jobs are equal, that the people in those jobs have to be paid the same.
Exactly. So there are legitimate reasons why people performing the same work are paid differently. So there are 4 main exceptions recognized under the Equal Pay Act, and the foremost of which being seniority. It's entirely acceptable to explain a pay discrepancy because one employee simply worked for your company longer. The fact that they make more money than another employee makes perfect sense. And again, merit. Nothing prevents you from paying one employee more than another because they do their job better. And again, quantity-based systems. If one employee is producing more than another, that's another legitimate reason for you to pay them more. And this last one, based on any factor other than sex. Well, this is kind of the catch-all for the Equal Pay Act. And this can mean, a variety of factors. For instance, education. If a person has a higher education than another, then that would explain why you pay them more. If they have more relevant prior work experience, again, that would go to show that there's a legitimate basis for you paying them more.
So what we're getting at here is the Equal Pay Act, again, and we'll be a little bit repetitive on this phrase, but it's important because Equal Pay Act has not been something that many businesses have had to worry about until the last few years, and because of a resetting of some things Spencer and I'll address in a second, it's something that we think is going to be of paramount importance to your business on a going forward basis. But equal pay does not mean you have to pay everyone the same. Equal pay, though, is if they are equal positions and you have people who are getting paid differently, and they're men and women, you had better be able to point to one of these exceptions, to the Department of Labor, to the EEOC. You better be able to prove why is that male employee being paid more than the female employee. Be careful, though, on some of these exceptions. If you're saying merit-based is the reason why you're going to be paying a man more than a woman, what does that performance evaluation show? Does it really show a significant difference between them to justify the pay? It goes back to something that we oftentimes talk about in these presentations when it comes to performance evaluations. Done properly, they are great tools. Done properly, a performance evaluation can explain the difference in pay. If you're outside of a union shop, you're allowed to pay people differently, and merit-based is a great way to do it, but you have to be able to prove it. And before we move on to some of the other factors, I want to also point out a hidden trap here on education. I've had a number of situations where a client, when being audited by the EEOC, would point to a male employee's education as being different than the woman, and that justified the pay. But please make sure that that education is actually linked to the position. I represented a country club at one time, and the essentially clubhouse attendants, the men were paid more than the women. And my client tried to justify it based on the fact that some of those male employees had gone to college. They had 2-year degrees. One of them even had a 4-year degree. And the women, for the most part, did not. Well, that kind of education has nothing to do with being a clubhouse attendant at a country club. So education alone cannot be your basis for this exception unless it is tied to the job itself.
So one other potential exception to the Equal Pay Act is how much did an employee make at a previous job?
So when you hire someone and you pay them $15 an hour for a position, and men in a comparable position or equal position are making a little bit more, you can defend yourself by saying, well, this person was actually, when they were hired by us, had been making $8 an hour, and this was a significant increase. On their application, they disclosed how much they were making and how much they wanted to make here. Right now, as the law sits today, you can defend yourself on an Equal Pay Act case by pointing to that employee's previous pay. But when we talk about a number of possible changes that are happening to the regulations and laws here, this may be going away. And the EEOC also hates you pointing to this because they're worried about simply perpetuating systemic discrimination. Just because one of your female employees had been subjected to lower pay because of her gender in her previous 3 jobs is not a good reason to continue it on. So be very, very careful if you're using an employee's previous pay in justifying how much you were paying them. We began the webinar by pointing to a couple of other legal changes that we expect to hit the employment universe because the Trump administration is going to be gutting and changing quite a bit of what the previous 8-year administration had instituted. So why should you be worried about equal pay in 2017? Well, you can't ignore the momentum of the last 8 years. The Obama administration was responsible for very significant changes directed at gender equality in the workforce. You shouldn't care about what is the Lilly Ledbetter Fair Pay Act, and you shouldn't care too much about the various executive orders that President Obama instituted. But what you should know, and your takeaway, is over the last 8 years, laws such as Lilly Ledbetter and the executive orders from President Obama gave very strong rights to employees who are challenging their pay. You can't defend yourself any longer on an Equal Pay Act claim saying, well, wait a minute, this female employee has worked for me for the last 10 years. She should have sued me for gender pay problems 10 years ago or 8 years ago. And this law only has a 2-year statute of limitations, so she's too late to sue me. Lilly Ledbetter struck that and said every time, every payday you pay this employee, the statute of limitations starts over again. So it's all fair game. There are no old claims anymore. They're all brand new. And the executive orders that President Obama issued really required a lot more transparency in pay. His executive orders were directed at anyone who has federal contracts or federal subcontractors because he couldn't reach into necessarily private employers. But those executive orders really set the stage for saying, you need to disclose to us and to the government what you're paying people in different positions, and employees are allowed to discuss their pay. And there can be no retaliation for employees who are sharing pay information. There was also a bill that was in Congress that was being pushed forward by the Obama administration that, but for the Trump victory, would have passed, and it was entitled the Pay Equity for All Act. And under this, it would have applied to private employers. It would have given absolute transparency to how employees are being paid, what they're being paid. Essentially, pay would be an open book in your workforce, and there could be no retaliation for employees discussing pay and getting together and talking about those and sharing that information. And it would have been illegal for you to consider in your hiring decisions how much someone made at their previous job. So this would have been a very, very dramatic change in the law. But this was the culmination of 8 years of momentum, and it is ingrained and embedded in the 2 federal agencies that are going to be overseeing this going forward, the Department of Labor and the Equal Employment Opportunity Commission. So watch out. You may be asking yourself, though, if this was something that's been gaining steam and momentum for the last 8 years, why haven't we seen more lawsuits about this? Where are the big cases? Well, they are out there. The EEOC and the Department of Labor have been very strategic about what they've been doing. But one of the reasons why transparency seems to be the name that's attached to the new 2017 equal pay issues is there weren't more lawsuits because female employees, female applicants, didn't know their rights were being violated. When you don't know pay information, applicants don't know if they're being discriminated against on pay. Your employees didn't know if they were being discriminated based upon pay. The government had no idea. And frankly, unless you're a pretty progressive employer and have been doing your own wage and hour self-audits, you probably didn't even know if you had pay inequities in your system. So with the new transparency that is out there in the law, with the absolute prohibition against any form of retaliation for employees discussing their pay, there will be, regardless of what President Trump and his administrators do, there will be a large uptick in Equal Pay Act suits because employees are going to know now more than ever. And one of the big tools that you all should be aware of why and how employees are going to know about this and the government's going to know, is there's a very big change to your annual EEO1 reporting. Now, if you don't know what an EEO-1 is, it probably means that you're classified as a small employer and you don't do business with the state or federal government as a contractor. If you are a private employer and have 100 or more employees, you should have been filing, and it is required, an annual EEO-1 report. And if you're a 50 or more employees, you had to do that if you had 50 or more employees, if you had federal contracts or federal subcontracts. So a lot of people who were registered for this webinar should have been filing annual EEO-1s, and if you haven't, you probably need to contact your employment counsel right away and figure out how you can play catch up on that. But there's a dramatic change, and Spencer's going to show you what the old EEO-1 form looked like and what the new form that is required starting this year, that gets filed next year, is going to require. And essentially the punchline when you look at these forms is now you are going to be telling the EEOC every year how much you're paying your employees.
So for those of you that are familiar with the old EEO-1 form, this is what the Section D for employment data would look like. Essentially, all you have to do in the old form is report the number of employees that fall within each classification and what job category they fall under. However, this is 1/5 of the new form and for Section D. Actually, it's 1/10. So this is the number of employees that fall within each of the 12 pay groups within a certain job category. So on the left, you can see that for your executive and senior level officials and managers, so the first job category of the EEO-1, there are 12 different pay bands where you have to report the aggregate number of employees whose W-2 compensation falls within one of the 12 pay bands.
So if one of your wonderful work responsibilities has been completing the annual EEO-1, you know, it wasn't the easiest thing in the world, but it wasn't that unwieldy. You were just reporting your numbers of men and women, and then within those categories, certain ethnicities, Asian, African American, Hispanics. It was all done for EEO reporting purposes. And as you can see on this screen here, and as Spencer just talked about, now you're going to be breaking those people down into 12 different job categories, and then within those job categories, you have to report their annual salaries. If that wasn't hard enough, Spencer, talk about the additional part of the new EEO-1.
So this is the second part of Section D, and as Jeff was saying, this adds an added level of complexity because for each employee that you report in the first section that falls within a certain pay band, not only do you have to report them falling under each pay band in the prior portion of Section D, you now have to aggregate the total number of hours worked for each employee that falls within their job category and the pay band. So you have to do it by sex and race and ethnicity. You have to aggregate the total number of hours worked by the employees that fall under the job category and pay band.
Yeah. So the punchline to this is, I think, twofold. On a practical level, if you're using a third-party payroll company, I would get in their ear very, very quickly and make sure that their software, if they're tracking your hours and positions, that they are accounting for the new EEO-1 form. Otherwise, you will be doing this manually yourself at the end of next year, and that does not look like a very fun process to start to add up hours for everyone in your organization. That's more of a practical business takeaway on it. The other, though, legal takeaway, and why this is very, very important, is the government is now going to have your pay information. They will look at raw numbers and figure out the pay disparity. They will see it in black and white in these forms, the pay disparity between men and women and the pay disparities between ethnicities. This is dangerous because this form is very blunt. The pay bands are out there, But the job categories don't necessarily fit your business, but you're going to have to shoehorn everyone into one of these. But what's missing on this is the why. Why might there be pay disparity? All of the exceptions that Spencer went through. So you're going to be faced with filing a report with the EEOC. This is something that a creative plaintiff's attorney is going to be able to request and find in discovery or in Freedom of Information Act requests. And you're immediately going to be on the defensive trying to defend against what on black and white might appear to be some pretty bad numbers that are actually fully justified. Beyond simply this form and new transparency, people knowing what your numbers are going to look like, the EEOC itself issued a strategic initiative 2 years ago to focus on gender pay equity claims. When you get an EEO charge, the average, the normal outcome of every charge that's filed is 97% have a finding of no probable cause. The person gets their 90-day right to sue, and most likely you're not going to hear from that person again in a lawsuit. It is rare, only 3% of the time do they find a probable cause of a violation. But over the last 2 years, when the EEOC has been looking at pay equity claims, 1/3 of them they have found probable cause in. And in half of those, they have decided to institute lawsuits on behalf of that charging party. Now, you may say, well, Trump's president now, we shouldn't have to worry about that. He's already been attacking a lot of the initiatives of the EEOC. And you might be right. We do think that that will lessen the resources that the EEOC is going to be putting into their stepped-up enforcement across the board. But you do have to be a little bit careful when it comes to pay equity. Candidate Trump, when asked about equal pay, he would never say, I believe in equal pay for equal work, because he has to say things his own way. His quote was pretty consistently, you're going to make the same if you do as good a job, or you should make the same amount of money if you do as good a job. What will remain to be seen coming up is, was he really parroting exactly what equal pay is, or did he think it means something different? Was he simply embracing the fact that equal pay requires not only equal work, but going through those 5 exceptions that Spencer talked about? So that'll remain to be seen. We could see pullback from the EEOC. We could see a suspension of the new EEO1 report that we just talked about. And most assuredly, we do not expect that pay equity for all bill to be passed into law. He will not push that forward because that had some very significant burdens on management. But we can't forget the Ivanka Trump factor. Ivanka Trump clearly has President Trump's ear, and she has been very vocal on a number of these issues. It is our best estimate right now of what we're going to see is the new laws. Probably the pay equity law will not move forward, but the existing initiatives probably will continue to have momentum. But even if the Trump administration had a huge pullback, if it canceled the new EEO1 reporting, you still are not completely out of the woods yet, are they, Spencer?
No, they're not, Jeff. Mainly because in the last 2 years, there's been a dramatic uptick in the amount of legislation proposed, enacted, or introduced into state legislatures. And listed in front of you are 20 states that in the last 2 years have attempted to bolster either their own Equal Pay Act or heighten the protections under the federal and heighten the level of protections afforded under the federal Equal Pay Act. So make sure as you all are setting your plans for 2017, and hopefully high on your agenda is going to be conducting an Equal Pay Act audit, which Spencer and I will walk you through here next. Don't get caught up in
what you see in the headlines of what necessarily the Trump administration is doing or not doing. We are seeing these, Spencer has just shown these of being the most active states. But there are also local municipalities. I believe the city of Philadelphia just passed its own laws regarding this. So especially you employers that are in multiple jurisdictions, make sure you're checking the box off in your state level as well, because these requirements are only expanding in each of these areas. Your takeaway from this webinar is hopefully a better appreciation or understanding that equal pay is different than simply gender discrimination or the Title VII discrimination based upon sex. Equal Pay Act is a different law. It doesn't require any intent to discriminate. If you go through and you say, I think that we treat men and women equally and there is no pay disparity, and you go through an audit because the EEOC has knocked on your door and you find one, all the good intentions in the world doesn't matter. It doesn't matter if women constitute the highest 50 paid people in your company. If you have positions that there's a pay disparity in there, this Equal Pay Act law is violated. And so your big takeaway here is you have to know the risks that are in front of you. And if you haven't done the audit, if you haven't done what we're about to talk about next, you don't know what your risks are yet. And this is a hidden trap for a lot of employers. The first thing you do before you even worry about a wage audit of your pay practices, number one, look at your job application. On your job application, do you ask an employee, when you list their prior work experience, do you have a box on there for what their prior salary was? What was their rate of pay? If you do, it is our advice to remove that from your applications. It is not against the law to ask for prior salary, but it could violate some of the state laws, and it certainly would run afoul of a lot of the expected regulations that were being rolled out, and the Trump administration might go either way on that. But we're asking you to go ahead and remove prior salary from your job application because you don't need it. What do you really do with that information? We recommend that the better approach is to simply ask an employee what pay are they expecting in the position that they're applying for, and go with that. About 2 years ago, we were defending a charge at the Equal Employment Opportunity Commission for a financial institution. They hired 3 commercial lenders at the same time, 2 men and a woman. And the 2 men were hired at a significantly higher pay rate than the female was. And the defense to this was not experience, not education, not merit. It was when they each applied, the 2 men requested a starting salary that was about $10,000 higher than the female. And the EEOC, when they audited this and investigated it, they hated to see that a woman hired at the same time was paid so much less. But they immediately dismissed the charge and took no action. They found no probable cause because all the client did was pay the person what they asked for. It would have been a very different result if what we had done was asked, what did you make at your last place of employment, and paid based upon that. Then we would have been in for some tough litigation. Go to your handbook. If you have something in your handbook that prohibits, a workplace rule that prohibits employees from talking about their pay, rip it out. It should have never been in there. That has always been a violation of the National Labor Relations Act and is a violation of the law. If you have something that tells employees their pay is confidential and they have to keep it confidential, rip it out. It doesn't belong in there. And then job descriptions. Before you even worry about an audit, Spencer gave you some of the characteristics of what equal work is, what equal positions are. If we're going to argue that positions are different, when I look at those job descriptions, they better show to me and leap off the page different skill, different work required, different education required, all of those factors. So beyond Disability Act or workers' comp, make sure those job descriptions are good and up to date. But what you really need to get into is do your compensation audit now, because knowledge is king. As we talked about, you don't know what you don't know. I don't want your first look at your internal numbers on pay disparities to be when you're filling out the EEO1 report. Do you have a problem? You need to know that before the government knows that. So steps for an audit. The first thing you're going to do is establish privilege. We're talking about here attorney-client privilege. Please do not try to do an audit on your own. If you do it without involving counsel, and we're not just pitching work for ourselves here, if you do an audit on your own, all of that information that you pull up, your internal communications about it, people talking about things, unfortunate texts or emails, or the data itself, is all going to be discoverable. If the government audits you, if you're ever sued, all of that will be subject to discovery. So the first thing you do is involve counsel and establish privilege. Work with your attorney to set up what the audit is going to look like, and you may do 95% of the audit yourself, but on the front end you've established privilege. You're then going to identify within your organization what are all of our job groupings. Take a look at the new EEO1 form. Even if you're not covered by it, even if you don't like it or it doesn't fit, use that as a good starting point for your matrix for identifying job groups. And then it's simple. Gather the data. How much are men and women getting paid? Look at the current year, look at 3 years, and look at 5-year averages. But gather the data and then look at it. Just do the math. Is there a pay disparity? And if so, why? If there's a good answer to why, make sure it's very, very clearly documented. What you may find is that there are great merit-based reasons, but people have done a horrible job of the performance evaluations. So what a great job to fix it. And if there's not a good reason, for goodness sake, make the changes. We're not suggesting that you make overnight changes. In fact, that's probably the worst way to handle it. But you need to come up with a plan then, if there is pay disparity, to address it. And then our final takeaway is to prevent these things. Again, sitting here today, you don't know what you don't know. You don't know if you have a problem or not. But once you've tackled this, it's not behind you. You still need to do a couple of things. Training your employees. Equal pay needs to be a new part of your training for anyone who's doing interviews, for anyone who's involved with evaluations, and educated people who are giving annual raises. Make sure they understand the need to justify differences between men and women. Once you've done this once, the annual audit is going to be easy. You're going to be able to spot check differences and challenge your managers. Ask them why. Again, make sure there's proof for the justification. And all of this comes down to the golden rule that we end every employment seminar with, which is be fair. Fairness governs all. The intricacies of any law doesn't matter one bit if you didn't treat someone fair or if you haven't given us the documentation to prove fairness. The Equal Pay Act, we believe that doing it the first time, doing the audit, it is a daunting task, but it is absolutely essential that it be done, that it be your #1 priority for 2017. And to the extent that you need any assistance with that, please contact your employment counsel. And if you don't presently have employment counsel that you regularly work with, we do hope that you consider contacting counsel at Spilman, Thomas & Battle. We are working with a number of clients already who started this last year, and we would love the opportunity to assist you in this. We are available to answer any questions for folks now, but also as a part of our webinar series, you get the balance of the day for a free Ask the Lawyer time. Feel free to shoot myself or Spencer an email anytime. It doesn't just have to be today, but follow up on this seminar, ask us some questions, and we're happy to provide additional information. Thank you everyone for attending, and please be on the lookout for upcoming additional webinars and alerts.
Jeff, we did have a couple of questions come in. You may have already answered. I think one of them you did already answer, but I'll go ahead and read them to you. The first being, can the seniority exception be based on time with company age or time in industry?
Yeah, that's a great question. When you are looking at those exceptions, seniority within the company is always a great way to do it, but prior work experience, especially when it is industry or job specific, is also a great way to do it. So absolutely to both of those, seniority at the company or within that industry.
And the other question, I think you did pretty well cover this one, but I'll go ahead and ask it as well. Is it now considered a bad practice to ask about past wages on job applications or in interviews?
Yes, and I'm glad you asked the question because you added the word "or in interviews." It's not illegal to ask about prior wages. As a best practices, we don't want it to be asked about. The reason I gave was, what are you really doing with that information? And it is potentially dangerous to have that because you could be, the EEOC is going to say you had that knowledge in your brain and you might have used it, you might have carried on older systemic discrimination in pay. So don't ask that information. It is our advice to remove it from your scripts of questions and interviews, as well as removing it from your applications.
And would you elaborate on the nepotism exception mentioned?
Sure. It was, I think, Spencer's effort to be a little bit cute, but the law under equal pay gave you these great criteria, and then it also threw this catch-on, quote, based on any factor other than sex. So if you're left defending yourself of how much you're paying employee A versus employee B, you need to point to things other than sex. Believe it or not, nepotism is one of those things you can point to. I paid the man more than the woman because it's the owner's nephew, right? And so if it's a reason other than gender, it's alive and kicking.
And we have another question. For an exempt employee, should partial day absences be charged against the employee?
So for an exempt employee, should partial day absences be counted against? This is, I guess, a wage and hour question, and the answer is going to be the famous lawyer, it depends. If it is for family medical leave, then you can deduct from pay under an intermittent leave under the Family Medical Leave Act. Other than that, exempt employees are not supposed to have their pay deducted in less than full day increments.
Thank you everyone for attending. Thank you Jeff and Spencer for putting together the presentation.
Thank you all for attending.
Thank you.